Thousands of mass lawsuits against online sellers are filed every year in federal courts throughout the United States, with about half being filed in the United States District Court for the Northern District of Illinois, located here in Chicago, and the remainder being filed in New York, Florida, and other courts. These suits collect tens or even hundreds of millions of dollars from online sellers every year, mostly through claims of counterfeiting, trademark infringement, unfair competition, copyright infringement, and design patent infringement. Despite how common these lawsuits are, there is very little information available online about how these cases actually work. What actually happens in these lawsuits? Can a plaintiff really restrict all the funds in your online store? How can a case like this be defended? This video is going to provide that information and more. So if you're interested in mass lawsuits against online sellers, either as a plaintiff looking to defend your brand or because you've just been sued, listen up. Let's start with how these lawsuits tend to unfold. Just like with every other lawsuit, they start with the plaintiff filing a complaint. The complaint will set forth the basic facts of the case and plaintiff's claims against the defendants. However, instead of actually naming the defendants, they will typically be filed against the partnerships and unincorporated associations identified on Schedule A. Schedule A is a separate document that will generally be filed under seal, which means the court will be able to see it, but the public cannot. Mass lawsuits against online sellers often involve counterfeiting, trademark infringement, unfair competition, copyright infringement, and design patent infringement claims. The most common complaint will be counterfeiting, unfair competition, and a state law claim. In Illinois, that would be an Illinois Uniform Deceptive Trade Practices Act claim. On the same day the complaint is filed, the plaintiff will move for a temporary restraining order, as well as expedited discovery and for a court order allowing electronic service. The temporary restraining order, which you'll hear called a TRO quite a bit, is going to allow the plaintiff to serve the platforms with the order that will require the platforms to restrict the operation of the seller's stores, as well as to restrict their financial accounts. In addition, the order will require the platforms to provide certain information about the sellers, including the names they provided to the platforms, the physical addresses that they used, as well as the email addresses that the sellers used to communicate with the platform. In addition, the platforms will provide the dollar amounts of sales of the URL or URLs indicated by the plaintiff as being infringing, as well as any similar products the platforms know of, the number of sales, the amount of money that the defendant has in their account with the platform, and any other financial accounts that the platform knows about, like a PayPal account, and potentially the information for any account that the seller sweeps funds into. In addition, the plaintiff will move for an order allowing expedited discovery from the defendants. That only really comes into play if a defendant chooses to fight the case instead of settle, and I'll discuss that more in a bit. Finally, the plaintiff will move for an order allowing electronic service, which means that instead of being forced to serve with a process server or by mail, the plaintiff will be allowed to serve the defendants via email or online publication on a website. To support these motions, the plaintiff will generally have to file certain evidence. This evidence will be attached to a declaration from an investigator that will be familiar with the operations of the plaintiff, information about the plaintiff's brand, their sales, etc. Generally, if the plaintiff actually purchased products from the defendants, there will be some indications in the evidence that they file with the court. There may be pictures of the defendant's products, but often the plaintiff will hold that in case any of the defendants contest jurisdiction. Rather, what you will typically see is a statement that the defendants, on information and belief, have shipped product into whatever district the plaintiff filed the lawsuit in, the Northern District of Illinois, for example. We'll get into why plaintiffs will not regularly unveil the evidence of actual purchases at this stage. In addition, the evidence that the plaintiff accumulated will be filed under seal, typically as an exhibit to the declaration of the investigator. Now, this evidence in the report is critical if a defendant intends to actually fight the lawsuit instead of settle. In addition, it is also important when negotiating settlement. For example, if the plaintiff includes an advertisement where the defendant posted a photo of the product with the mark on it, that is pretty solid evidence of trademark infringement. On the other hand, if the evidence doesn't include the mark at all, that is a pretty good sign that the plaintiff may be stretching the evidence, and the case can be settled quickly and cheaply. Right after a plaintiff files a case like this, certain services, like seller defense and others, will often report that the case has been filed, what the asserted mark is, so forth and so on. However, by the time that seller defense publishes that a filing took place, the damage will generally be done. The plaintiff will have their evidence, and about the only thing that a seller could conceivably do is immediately close their store down and withdraw any funds, a step that most sellers are not willing to take. And that wraps up the initial filing. Generally, a few days after filing, the court will grant the plaintiff's motions, meaning the court will grant a temporary restraining order restricting the seller's account, allow the plaintiff to take expedited discovery, and to provide service to the platforms and defendants electronically. This motion will be granted ex parte, meaning that the defendants will not have any opportunity at all to contest the case or fight this relief at this point. The court will then provide a signed temporary restraining order to the plaintiff. The temporary restraining order will be sealed at this point, meaning that only the court, the plaintiff, and those that the plaintiff shares it with will know its contents. The plaintiff will then serve the order on the online platforms, Amazon, eBay, Walmart, along with any additional information about the listings that the plaintiff asserts are infringing. The platforms will then impose the TRO, meaning they will take the challenge listings offline and restrict funds coming out of the seller's accounts. The platforms will also provide certain information to the plaintiff. The information the platforms provide varies from platform to platform. At a minimum, it will include any names that were used to register the store, the physical address that is associated with the store, all email addresses that the platform uses to communicate with the store, the dollar amount of the sales of the accused listings, the total number of the accused listings, and the dollar amount that is restricted in the account used with the online store. In addition, other information may be provided. That information often includes the total sales of the store, whether sales were made in the United States, whether sales were made in a particular state, and, if the plaintiff asks for it, and most do now, any other financial accounts that the platform knows about. This will include any accounts that take payments like PayPal, as well as any accounts that the defendant sweeps funds into, often a bank account in an overseas bank. The platforms will then notify the defendants via email of the lawsuit and that their accounts are restricted. Once the plaintiff receives the information from the platforms, the plaintiff will then serve the defendants via email, online publication, or both. Once the defendants have been served with the complaint, they have 21 days to answer the complaint, negotiate a settlement with the plaintiff, or negotiate extra time to answer the complaint with the plaintiff's attorney. If a defendant fails to do any of the three, then that defendant is technically in default, and the plaintiff can move for an order reflecting the same. However, for the most part, the plaintiff will not immediately default the defendant. Rather, the plaintiff will work to negotiate settlements with as many defendants as possible. Most of these cases are handled by attorneys on a contingent fee. I mean, they're paid a portion of what they recover. So they are motivated to negotiate as many settlements as possible with the defendants. Those settlements will always require the defendant stop selling the infringing product or products, as well as making some payment of money to the plaintiff. Now, given the information that the plaintiff received from the platforms, the plaintiff has a lot of leverage when negotiating with the defendants. The plaintiff will know exactly what the sales of the infringing items are, exactly how much money is restricted, and in some cases will know the total sales of the store. The plaintiff is going to use all this leverage to extract as high of a settlement as possible. It basically makes it impossible for a defendant with large amounts of sales to claim poverty. Now, what determines the typical amount of the settlement? There are a lot of factors. The number of sales, the dollar amount of sales, how much money is restricted with the online platform, the attitude of the plaintiff, the reputation of the plaintiff's attorney, the attitude of the plaintiff's attorney, the willingness of a defendant to fight and spend money, the reputation of the defendant's attorney, and the attitude of the defendant's attorney. A lot of defendants will settle early, days after service, as often the parties that settle earliest will get the best deals, especially if their attorney has an established relationship with the plaintiff's attorney. However, some parties will appear and either answer, file a motion, or request an extension from the plaintiff's attorney. Most of these will be larger stores or stores that have a lot of money restricted. In addition, often a single defendant will own many stores, sometimes 10 or more in the same lawsuit. And many times those stores will band together and defend as well. A lot of the stores that appear and defend are used to having their stores sued in these types of cases and will have attorneys on retainer to quickly deal with the lawsuits. For the defendants that appear and fight the case, the court will often order that those defendants be severed from the main case. So it's not uncommon for 1 to 3 groups of defendants to be severed into their own cases, and those cases will proceed at their own pace. These cases may take months or years to resolve, depending on how they proceed, and will involve discovery, often into the identity of owners, their business structures, their business records, including tax records, sales of the accused products, when the organizations had knowledge of the asserted marks, other accusations of trademark infringement, and other information. In most cases, during the entire pendency of the case, the stores will be subject to the temporary restraining order, including an asset freeze. Finally, some defendants are going to ignore the lawsuit and they will be defaulted. Although until a plaintiff actually moves for default, there is a chance to negotiate a settlement or to appear and defend a case. A court will often excuse a late filed answer. For most cases, the time from initial filing to default is 3 to 4 months. And that covers how these cases actually progress. How about defenses? There are some defenses that probably will not work, but need to be investigated in every case. For example, the issue of service of process has been settled. The plaintiff will have an order allowing the plaintiff to serve the defendants electronically, typically via either email or online publication. Nonetheless, in some cases, a plaintiff will fail to provide proper service. They may fail to provide service at all, or the service that they do provide does not comply with the order. In such a case, service of process should be challenged. In addition, if a defendant is a domestic defendant, meaning domiciled in the United States, most courts will require that a plaintiff serve them through normal process. This can often be used to leverage a much better settlement. Quite frankly, if a foreign defendant has to pay $10,000, a domestic defendant will often have to pay $2,500 or even a bit less. It can make that much of a difference. Another defense that has worked in the past is lack of personal jurisdiction. Many plaintiffs now routinely request and receive from the platforms the number of U.S. sales and the number of sales in the state where the case was filed. However, if a defendant is sued in a state where there were no sales, personal jurisdiction can still be challenged. In Illinois, at least, it is still up in the air whether or not lack of sales is an actual valid defense. The Seventh Circuit, the Court of Appeals that supervises Illinois district courts, issued an opinion that suggests that no sales is sufficient for personal jurisdiction as long as the product was offered for sale. And most judges in the Northern District of Illinois, the most popular district for these types of cases, will not require a sale in the district to find personal jurisdiction. However, if there truly are no sales, a motion for lack of personal jurisdiction can work in certain circumstances. One issue to be aware of is that more or less all plaintiff firms, at least the competent ones, will now place trap purchases. In particular, the most common tactic is to place 2 trap purchases. The first one will be from a random person, someone that the firm pays a small amount to make purchases that has no ties to the law firm. When our firm does these types of cases, we use college students for these types of purchases. A few days later, we will place a second trap purchase directly to our law firm. In many cases, the second purchase will be rejected by the seller because the name of our firm has been published by various online sites as handling plaintiff cases. So a lot of online sellers just will not deal with us. However, what typically happens is that the online platform accepts the order, and then a day or two later, the seller manually cancels the order. We keep track of all of this, and a lot of other firms do as well. Then, when a motion challenging personal jurisdiction is filed, we ask for jurisdictional discovery and request any information on Illinois sales. If the seller tells the truth, their motion fails. If they lie, we produce the evidence that we have, and their motion fails, and we get an award of attorney's fees. And in most cases, the defendant will be defaulted. So be very careful when pursuing a personal jurisdiction defense. However, even with the risk, it is a defense that can work and that we will occasionally assert for our clients. The most effective defenses are typically those that contest the merits. This covers the whole range of trademark, copyright, and design patent defenses. For example, there are many ways to contest trademark infringement. One is to claim that the mark was never used as a trademark and therefore could not confuse consumers as to source. A good example of this would be when a mark is used comparatively, such as our stapler performs just as well as brand X. In many cases, if a store can mount a very strong defense, a plaintiff will be willing to dismiss that store from the case. However, most defenses are not slam dunks and can be argued both ways. In those cases, the plaintiff will probably sever the defending stores out into a separate case and allow the court to rule on the matter after discovery is taken. Most such cases will terminate with a motion for summary judgment one way or the other after a year or so of litigation. During the time the litigation is pending, it is extremely likely that the TRO and asset freeze will remain pending, although the terms of the asset freeze can be negotiated or reduced. Often judges will limit the asset freeze to $50,000 or $100,000 per store once the court sees that a good faith defense is being asserted. Now, when does it actually make sense for an online store to fight a mass lawsuit like this? I would submit that it is primarily a cost-benefit analysis. If the product is not important to you and the plaintiff's demand for settlement is not overly high, even if it is $10,000, then settlement is usually going to be a lot less expensive than litigation. On the other hand, if the plaintiff is demanding a large sum, $100,000 or even more, or the product is important to the operation of your store, then litigating the case can be your only option. Generally, you want to litigate the case long enough to convince the plaintiff to offer better terms. So if the plaintiff's demand starts at $100,000, if you spend $20,000 in attorney's fees, but get the plaintiff to drop its demand to $50,000, you are still $30,000 ahead. Achieving a $0 settlement or verdict is rarely achievable and should generally not be the objective, although there are exceptions. Rather, the objective is to drive down the number as much as you can. Something to keep in mind is that litigation fees are essentially unbounded. No credible attorney that I am aware of will defend a case like this on a fixed fee basis. So you're going to have to pay based on the hour or on a task-by-task basis. That sum can very quickly add up. Nonetheless, in the right circumstances, litigation is definitely the best option. In some cases, it's the only option. Last thoughts. These cases are an extremely powerful tool that have been used for years now by brands to fight online counterfeiting. Some brands use these cases as a major profit center, and we are always looking for new clients to help monetize their brands and represent in cases just like this. In addition, if you're sued in a case like this, these cases can usually be settled or defended. A lot of the amount of the settlement depends on how credible the firm that you have representing you is. Our firm has a solid reputation for doing a good job defending or settling these cases. Of course, my law firm can help you with all this. All of our attorneys are very familiar with these types of lawsuits, and we have handled them for both plaintiffs and defendants. For plaintiffs, we have collected tens of millions of dollars, and for defendants, we have handled numerous lawsuits that have resulted in a $0 settlement or a $0 verdict. Last but not least, have a fantastic day and take good care of yourself and your family. Bye-bye.